Good morning, good morning. We are doing sound check now. Hi, are you logging from KL? Hi, most people logging from KL, huh? Hello. So we can start again, huh? Hi, good morning, everybody. Today we are so happy to invite this pretty lady, Miss Gita, to share with us how much copying is too much. Miss Gita is a director of trademarks and design division at CAS International. Wow! So you see this pretty and young lady. So today, outline is right click, copy and paste. Repeat a few times, and your article is complete. Your slides are done. Your blog is updated. Is copying from the internet lawful? What is copyright and what type of copying constitute copyright infringement? Then let's explore this topic truly so that you don't run afoul of the law. So now I pass the mic to Miss Gita. Let Miss Gita to share with us how much is copying is too much. Miss Gita, the floor is yours.
Thank you, Vivian. Thank you for the introduction as well. Hello, everyone. Well, welcome, everyone. Thank you so much for sharing your Thursday morning with me. How much copying is too much? It's a very interesting topic, mainly because, number one, everyone uses the internet, whether it's through the PC or through the laptop or through your mobile phone. Every business in this day and age has a website or should have a website. So the topic relates to everyone actually, because sometimes the material that we put up on our website, put up on our blogs, social media may not be our own original material. And if it's not your own original material, it actually means that we're copying. So how much copying is too much? And when we say is too much, we mean in law, legally. Is it lawful or is it unlawful? So that's what the topic for today is. I myself have 13 years experience in CAS. I head one department, the Trademarks, Copyright and Design department. And we deal with local clients and foreign clients and advise them on anything and everything to do with intellectual property rights. Intellectual property rights is the umbrella term for various types of rights that people create. So you have patents for technology, trademarks for brands, designs, industrial designs for the exterior look of a product or the interior look of the product. And then you have copyright. These are the four main branches of intellectual property right. Copyright. So let's explore what is copyright. So the material that you use on your website, on your blog, on forums, and on articles, these material include images, statistics and graphs, and excerpts of articles. So this is what, so you when you think of what is it up there on the internet, it's always artistic work or literary work. This artistic work, literary work, and other examples, photographs, articles and tweets, all of these are a form of creative expression, and that is a form of copyright. So the law provides that all copyright matters are protected. It's a type of intellectual property right, and the way that it's expressed are different. One article, it could be a book being read out by someone. It could be a book being performed in a play. So that copyright can be expressed through various mediums. It can be visual medium, it could be through the multimedia, through writing, written work, through sound, in 3 dimensions, through motion, which is performances, acting it out. So there is the work itself, and then there is the derivative of the work, or the transformative work. So there's various types of protection and various types of work. That's what copyright is. Now, we see copyright every day. Creative work is around us all the time. So these are examples of other creative work that's also under copyright law. We have paintings, photos, songs, novels, poems, plays, music, choreographies, sculptures, buildings, movies, and computer games. So all of these are also a form of copyright. Copyright protects original works, and copyright protects a wide range of works. So the word copyright itself, it's very interesting because in the English language, and I think many of you who have friends in the advertising field, sometimes you hear this word in their field as well, because they call themselves a copywriter. A copywriter is a person who actually writes creatively in the advertising field for various companies. You can write a company profile, and that's copywriting. You can write an advertisement and you have creative text underneath the advertisement, that's copywriting. So it gets confused with intellectual property law because copyright is a form of property right. It's an intellectual property right. Someone has ownership on literary work and artistic work, and that is called copyright. That type of work is called copyright. So please feel free to jot down any questions that you may have on this part so that we can address them at the end of this webinar. So copyright protects a wide range of works, and some examples were given before. So yeah, so there's difference between copywriting in copywriters and copywriting in the advertising field, because that also means that they're being creative with the text, and copyright in intellectual property law. So copyright in intellectual property law protects a wide range of works. So the easiest way actually is to see whether is it artistic work, is it literary work. So written work, literary work, covers books, speeches, magazines, newspaper, articles, novels, stories, poems, essays, plays, and so on. So in businesses, you'll have operation manuals, written instructions. So operation manuals, written instructions for franchisees, for example, they have operation manuals. And some franchisors have operation manuals, and if a franchisee takes the operation manual, opens their own restaurant, if it's a F&B business, and reuses the operation manual, photocopies it, and passes it around, that's an infringement of copyright. So all of this enjoy copyright. Musical works, musical compositions, lyrics, songs, and ringtones in all type of formats. So formats are the mediums they're listened in, CD3, MP3, MP4 nowadays. Then you have artistic works, drawings, both technical, engineering, scenic. Then you have paintings, photographs, so sculptures, architectural works, maps, dramatic and choreographic works, films and multimedia products, computer programs. So yes, even computer programs considered copyright. That the literary work is actually in the programming language. So programming language has 1010, all in different formats, and that's protected by copyright as well. So that the earlier slides and actually gives you an indication of how wide copyright is. It protects various types of work. What is important to note, however, is that it does not protect concepts and facts, but only the expression of it. So basically, if you have an idea in your head, that remains as an idea. Only when the idea is transferred into a medium, then you have copyright. So an example is if your mom or yourself have all these recipes in your head, and you write and you talk about the recipes to a friend, and you actually, then your friend goes and writes a book. Can you sue that friend who writes a book, a recipe book, from all the stuff that you've been talking to them and telling them about it? So, okay, so there's a few issues there. The ideas in your head can't be protected. But your friend has taken the ideas in their head and written a recipe book. So can you sue them for copyright infringement? No, you can't. You can't because you didn't have it written. You didn't have it transferred to a medium first. So you can't sue them for copyright infringement. They have not copied any artistic work or literary work. But you might have a case for confidential information. It might be a breach of confidential information if you shared it with them on the basis that it was confidential. So that's a whole other talk, and we've done talks on confidential information before, of breach of confidential information. But for the purpose of today's one, because we're talking about work on the internet, in the earlier slides and now the introductions, more so you understand the concept of copyright. So let's take this example again, this recipe book. If you have published a recipe book and someone takes and buys this book of MPH, and they actually open an Indian restaurant and actually create all the dishes in the Indian restaurant based on the recipes in the book, can you sue them? So you have this book, they've copied the recipes, copied it and put it into practice. Is there any cause of action against them? And the answer is no. So the recipe book is for you to share your knowledge with the world, and they are using the practice of the book. And they've started a restaurant and running a restaurant on that. So there's no lawful action that you can take against them. But on the other hand, if that other party has photocopied your book or managed to get another publisher and reproduced your book, that is an act of infringement. That is copyright infringement. They've copied your work. Them learning the recipes and executing it is not an action for infringement. It can get quite confusing, so I hope that's clear. And if it's not, please do jot it down and we can address all of your questions later. Another thing I would like to highlight to everyone listening in is relate it to your own business, because that's the best way to learn and best way to see whether you are infringing anyone else's rights or anyone else is infringing your rights. So why is copyright so important? Why is ownership of copyright so important? This is because it gives the person who created that work exclusive rights. So the person who created that work could be an author or a designer, and they have exclusive rights to various aspects of commercializing the work. And some of the aspects are as shown below. So they get to reproduce the work, including any form of copying such as photocopying, scanning, distributing, selling. So the rights to reproduce the work remains with only the author or the designer, so the owner of the work. They have also the right to translate the work into another language. So when you are traveling and you see a Harry Potter version in the Thai language or in a Russian language, in whichever other languages that you've seen when you're traveling the world, the books can only be translated if they have permission from J.K. Rowling. So the author, the owner, must have given permission to translate and also reap royalties. So she would have charged for that translation as well. So that's a right of the owner of the copyright. The owner of the copyright also has the right to adapt the work. That's alteration or transformation of the work. So examples shown is a novel being made into a movie. This is getting more and more common. In fact, I think most writers these days write a novel with the intention that it'll be picked up by producers and be converted into a movie. So when a novel has copyright on its own and made into a movie, can you sue them? See, that's why I say my earlier example of the restaurant can be quite confusing. So people write a recipe book, but someone who buys it and exercises the recipe in their Indian restaurant cannot sue the author of the recipe. But yet a novel, when it's made into a movie, it's considered transformation. So it gets tricky in this actual example. But when a novel is made into a movie, the script stays, most of the time, it changes, but not to a large extent. The whole storyline remains the same. So in this case, it is a transformation of the work, and that the owner has the rights to that, to the movie as well. Animating a drawing into a cartoon, or character merchandising, toys and t-shirts. Hello Kitty, for example, Sanrio, with a company in Japan which created Hello Kitty, makes more income, more revenue from licensing the images that they have than they do from selling their own products. So their whole business model is to license it in as many versions as possible and many merchandises as possible and worldwide, and to reap in the licensing rewards. So that's also an act of copyright. They're licensing the copyright they have in the images that they've created. So that's adaptation of work. Examples of other adaptations. So these were all drawings. These were all drawings to begin with. Peanuts, the movie, for example, it started with a comic strip. So that's the copyright in a comic strip. And then the stories were all converted into a movie. Other rights of the author is rights to exhibit or perform the work in public. So by displaying the results of findings in an exhibition, or speaking from training materials in a seminar, recording the talk into a CD and playing the CD in a car. So all these are rights to exhibit the work or perform the work. So when restaurants play music, they actually pay a copyright licensing fee to a certain body. In Malaysia, there's 3 bodies. And this is called a collective agency. A collective agency collects royalty fees on behalf of various music producers in a country. It just makes it a lot easier for singers and producers and composers to reap the royalty rewards, as opposed to the singers themselves going and knocking on each restaurant and charging them a certain fee. So the bodies like these are very common and they exist in all countries. That's how they actually collect royalty income from establishments that use their music. Then the rights of the author also goes on to distributing the work and broadcasting the work, showing the work or playing a song on the radio, showing it on TV, playing a song on a PA system in a factory, or rebroadcasting as well, and communicating the work to the public. So this is why we come in, which is we're talking about today about things on the internet, uploading the work onto the internet, publishing the work in magazines or newsletters. So communicating the work. So the range of the rights of the owner is vast. You can see from one piece of original work, there's so many ways the owner can actually commercialize the work. These various alternatives in which they can actually make money from what they have created is an exclusive right of the owner, which means no one else has this right, only the owner. If anyone wants rights, wants permission to use these rights, they have to contact the owner and get permission. That's why it's really important. Number one, to know whether you have any copyright in your own business. Are you utilizing it to your advantage? Can you license it out to other people who are willing to pay you for it? And to see whether you're misusing other people's rights. So that brings us to the website. Okay, let's see. Who owns the copyright on your website? So the rule of thumb is, and this is for any copyright matter, any work that's created, the rule of thumb is the creator is the owner, unless there is any agreement to the contrary. So anything that's created, any slides, any website, anything that's created, the rule of thumb is the creator is the owner. Then we have to actually see other aspects. So we'll come to that. When it says whether there is any other agreement to the contrary, we're looking at actually 2 other aspects, but I'll come to that shortly. So back to the website. You have to break down each aspect of your website and ask yourself who created them. So why do I say break down the aspects of the website? So website developers will know what we're talking about. A website, what you see in a website is the front end. The front end is the design you're seeing, the user interface. There is a back end as well, and that's where the content is. The content, the HTML coding, images in their codes. So that's the back end. So there's, and then the photographs and videos are front end as well. So you're looking at various aspects of the website and who created all of those. So you're looking at, yes, who created the content? Because sometimes, no, actually most times, the website is not created by a sole person. There's photographs obtained from elsewhere, there's videos obtained from elsewhere. The design on the front end might include design created by someone else, and the back end might be a programmer or a website developer. So it's various parties that could play a part in having a website up. So you have to see who created this, and do you have the rights to every element of it that was created. So if you engage others to design your website, write content, or take images, what should you do? So the rule of thumb is copyright resides with the person who created the work. So if that's the rule of thumb, what we have to do is the copyright is transferred from the creator to you. So the work may be passed to you, being the website might be given to you, the front end and the back end and all the source codes may be given to you in a thumb drive, in a CD-ROM. But copyright is not a physical, tangible matter. We're talking about rights in the work. So the rights, the intellectual property rights in the work may still belong with the other party, even though physical transfer has been done. I hope this is clear to many of you. So now that the copyright may still reside with the other party, because he is the owner of the work, we need to make sure that the copyright is transferred to you. How do we do that? Well, you can have a copyright assignment agreement. So anything that someone else creates, and if there's copyrights in it, so you'll be asking, the usual question we hear from clients is, what is copyright? So address that part of it in the earlier part of the webinar. So now you know what is copyright. Now you have seen, okay, I have copyright and I've asked someone to do it, and now copyright resides to him because he's the creator. Let it transfer back to me. So then you get a copyright assignment agreement. Have an IP lawyer draft it for you, and it usually is, if it's not too, usually it's quite simple depending on the work. Then the other option you have is, if there's very regularly you're getting work commissioned, in that contract where you commission someone to do something, have a clause in that contract. If you don't have a contract when you're asking someone to commission work for you, get work done for you, please have a contract. Because apart from getting them, most of the time what is always finalized is payment terms. But apart from payment terms, getting copyright transfer is equally important. So have a simple agreement where, including payment terms, you have a clause saying that the work, the copyright residing in this, is transferred to you as this is commissioned work. So a valid written agreement between the parties pretty much solves the whole problem about copyright residing in the creator. So ensure the work is original. That's also very important. When you get someone to commission the work, which is why agreement for commissioning work is important, is they're commissioning work to you. What is the guarantee that the work they're delivering to you is original? So back to the website. So if you're having your website designed, you have to ensure that the images used on the website is original. You have to ensure that the text used on the website is original. You have to ensure that the videos posted are original, because as much as the website may look amazing and you'll be very thankful to your website developer, it might not be original work. And the last thing you want is getting a cease and desist letter from a third party claiming that you have infringed your rights. So an example I can share is, we once had a client who came to us and we had to address the issue. And the issue was, they found a competitor using a photo of theirs in the competitor's website. And it was very clear that it was our client's photo, and the reason being that our client's trademark appeared in the photo, and it was visible that it was a project that our client worked on. It was a project our client worked on, and our competitors used the photos of that project to show to their clients that they also can deliver these similar type of projects. So for obvious reasons, I can't name names and I can't give details of that dispute that we had. But this is the use of someone else's photograph on a website that had brought them in, that delivered them into hot soup. Because in the end, we sent a letter saying that these are our clients' rights. Please remove that from your website, or we'll take you to court. So it's an issue of very, very important that when you put anything up on websites and blogs and so on, or engage someone to do it for you, ensure that the work the other person is delivering is original. So how do you do that? Well, back to the agreement. So incorporate that as a term in the agreement. Ensure that the agreement, when you commission work, specifies that the work delivered is original, and that if it is not, you are subsequently sued for copyright infringement. The other party will indemnify you for the full damages. So what does that mean? It means that in the agreement, you're getting a guarantee from them that, okay, if I'm sued for this, I'm not going to pay anything from my own pocket. You must pay me. You must pay the party that's suing me for any damages or costs that I suffer. So in that way, the other party who is creating the work for you will also be more careful to ensure that what they're creating or what they are delivering is original. Content. So having that in the agreement is good, but sometimes you can also check if you've got anyone creating work for you. You can double check online to ensure that the work is not already existing in Google. A lot of universities do this. A lot of universities have even tools available to ensure that the work is original from their students. So there are various tools available, but you can also use a Google search engine, reproduce the sentence or 2 sentences from the article that you have in front of you or work that people have given you saying it's original, and double check whether is it original. Just actually being very, very careful with everything you have when you post online is important. So ask questions. Where did you get that from? Who created this? Did you write this yourself? It's an important habit to have, because where did it come from? Whose originality is it? With regards to photograph and designs, similarly, it might be belonging to someone else. So photographs are usually taken from stock image sites, and stock image sites charge a license fee. Sometimes the stock image sites provide that it can be used for free at no fee and no cost, but only for certain purposes. So you have to then analyze the purpose. Is the purpose that they've highlighted that it can be used for free? Does your purpose fall within the definition of the purpose? Do be very careful, because sometimes if it's unclear, get legal advice. So if no license fee is paid, and there was a mere copy and paste on that site, then there's copyright infringement. So for those of you who are aware of Shutterstock, you'll see the Shutterstock has a watermark on their photos. And that's the reason they want to prevent people from merely copying and pasting their images. But with Google Images coming about, it's made the act of click, copy, and paste a lot easier. With Google Images, people find images and use them all the time. But all those images have copyright on them. They belong to someone. Using that image without permission is unlawful and dangerous. So now, what if your work was created by your employee? Who owns the copyright then? You still need an agreement? You get business owners ask you this, like, he's my employee, why do I need an agreement? So the rule of thumb, what does the rule of thumb say again? So the rule of thumb, always go back to the rule of thumb. So the rule of thumb says that the person who creates the work owns the rights. So in this case, again, if the employee created the work, the employee owns the copyright. However, our copyright law provides that whatever an employee creates, if it's within the job scope, then the employer owns the rights, meaning that it's transferred to the employer automatically. There's no need for an agreement. So then it comes to a question of what is his job scope? What is the employee's job scope? Are employees always just working within their job scope? Businesses normally encourage the employees to think outside the box, look at other angles of the business, look at other angles of that sales aspect of his job. So there's always that aspect as well. So it's very dangerous to rely on this, on that whatever's in his job scope, if he was created within his job scope, then it transfers to the employer. So on the question, do you still need an agreement? It is advisable to have a clause in the employment agreement to state that whatever that's created transfers to the employer. So if it's not in the job scope, it doesn't transfer to the employer. So you can be quite clear about this in the employment agreement or in a copyright assignment agreement if there's a specific project being worked on. So what if you take the works from other websites, images, photographs, and videos? So we did talk about it. Is that copyright infringement? Is the acknowledgement of source good enough? So back to rule of thumb. Rule of thumb is creator owns the rights, right? Employee, sometimes the rights transfers to the employer. People who commission the work, our act also provides that if people commission the work, the copyright in the work transfers to the person who commissioned the work. But having said that, it can be disputed. Both of these actually can be disputed. So it's very important to have it in agreement or have it in a clause in any contracts between the parties. So if you take the work from other images, photographs, and videos from other websites, is that copyright infringement? So the question you ask yourself, does someone own the rights to that work? If you didn't create it, then it's a clear answer of yes. If you didn't create that work and you got it from somewhere else, who created it? It didn't drop down from the sky. Somebody exerted creative thought and effort and created work. So yes, someone else owns the rights. Is that copyright infringement? is acknowledgement of source good enough? So that's a second question. The second question we get it quite often because the act, some copyright acts in different countries have different defenses, and some say that acknowledgement of source of good is good enough. So what is the case? What is considered copying in law? So they have a quantitative analysis against the qualitative analysis. Quantitative means that the copying, there's a substantial amount of copying done. And then there's qualitative copying saying, I haven't copied a lot, I've just copied a little part of the work, but a very important part has been copied. A significant part has been copied. So explaining this one a bit more is, the example I can give is, let's say an article. There's an article written by a researcher who also has a graph as part of the article. But a chunk of time of the researcher went into gathering information and data to plot that graph. Let's say it's the number of diabetic people in the country, in Malaysia, especially since it's such a big issue and it's constantly increasing as years go on. So the researcher actually had plotted a graph, and in the graph, it talks about the various races in the country and which races are more prone to diabetic and why. So then the whole article actually goes on to explain the research methods, the graph itself, what's the impact, why is the graph that way, and so on. So I come along and I'm doing a thesis for my PhD, and that graph is extremely useful for my thesis. So I don't copy the article, the explanation behind the graph, I copy the graph. I take the graph, which is probably 20% or 10% of the article, and use it for my thesis. Is that copyright infringement? So rule of thumb, did I create a graph? No, I didn't create it. Did I copy the graph? Yes, I copied it, but I didn't copy that much of the article. It was just like 20%. So is 20% of copying considered copyright infringement? I copied such a small amount. How can there be copyright infringement? So when copyright infringement cases come to us, we actually have to assess, number one, who created it? Number two, okay, you didn't create it, but you copied it. But how much do you copy it? So the how much you copy it is such a subjective matter. That's why we're talking about whether it's quantitative or qualitative. Quantitative meaning that if you copied a substantial part of it, it's considered copyright infringement. But in cases where there isn't substantial amount of copying and there's very little copying, but that little copying is a significant part of the work, then it's still considered copyright infringement. So the example I gave you where I copied the graph, well, it is a small part of the work, but all the effort that went into it, and that specific graph that was created based on the information and research and the data that the person has collected, is a significant part of their work, significant part of their written work. So there is copyright infringement. So when you come to percentages, when you compare work, it's very difficult to say, oh, 70% of copying is copyright infringement, or 60%. The courts will definitely find this case positive. So it's very difficult to answer that question. So it really becomes a question of what was copied, and then we analyze what was copied. Was it a substantial amount? If it wasn't a substantial amount, was it a significant part? So this part of what is considered copying, what falls under copyright infringement, it's not so easy to say, yes, if you do 60%, it's copyright infringement. If you do 30%, it's not copyright infringement. It's such a subjective matter. So is that copyright infringement? The answer to that is, it depends. It depends on what was copied, how much was copied. Okay, let's go to the next. So that brings us to the doctrine of fair use, the right of control. So the right of control of copyright does not include by way of fair dealing for purpose of non-profit. Okay, there's too much words here. So what I'm going to say is the defense in copyright in Malaysia and in US, different countries have different defenses, but it's still along the same concept and reasons. And the defense is that if you use the copyright work for fair use, for reasons such as research, private study, criticism, review of the work, reporting of current events, teaching, scholarships, anything along those lines, that is considered fair use. So it means that copyright is being used, but And there is copyright infringement, but this is a defense. I'm using it without permission, but I'm using it for fair use. Also for parody, pastiche, and caricature, so like to make fun of something. So how can you make fun of something without referring to that something? So you know about like how the US, there's freedom of speech, and on Saturday night shows and David Letterman, there's always people or the talk show hosts taking or making fun of the president or politicians and so on. So they need to refer to the person to make fun about them. So that's why it's considered to be fair use. Inclusion in a film or broadcast of any artistic work situated in a place where it can be viewed by public. So this, for example, incidental appearances of copyright, meaning that if you are filming a movie and you're filming it in the Louvre in Paris, and the Mona Lisa is hanging on the wall there. So what happened, the movie there's a fight, and in the background Mona Lisa is there. Is there copyright infringement because Mona Lisa, the painting, appears in the movie? So this kind of defenses kind of allows filmmakers and producers to go on making movies and films without having to constantly worry about small images that might. Mona Lisa is not actually a small image, so maybe it's a bad example. But the rights of copyright owners in the background of a movie, when it's not highlighted, it's just a bypassing, it's an incidental thing. So this defense gives all of them those rights to still do what they're doing, by even though they are using infringing the copyright, it's by fair use. So that's what this defense provides. Actually, so I don't know whether, since we're talking about movies, whether any of the attendees, those tuning in, remember The Hangover 2. The Hangover 2 had a very interesting copyright case. After one of the nights, the crazy nights, the four of them had in Hangover 2, I can't remember which city. I think Hangover 1 was in Vegas. But after one of the crazy nights that the one of them had, Stu had, the next day he wakes up and he has a tattoo on his face. So that tattoo became a dispute because it was a replica of a tattoo specifically designed for Mike Tyson. The tattoo artist, Victor Whitwell, actually sued Warner Brothers when he saw the movie and saw his own design of a tattoo appear in the movie. So this is an example of copyright infringement. They've used the artistic work of the tattoo artist, but they've not obtained any permission from Victor. So Victor then sued Warner Brothers, and both parties settled this matter out of court. So it's an example of when you're using a third party's work, artistic work or literary work, do you have permission? If you don't have permission, is it fair use? So in this case, it was not an incidental matter. It was not just the background of the movie. It was the main character having the tattoo on his face. So it was one of a very visible part of the movie. So they should have got clearance and they should have got copyright licensing before that was even done. So back to online postings. Let's look at other online postings. Do you own the copyright in your tweets? How are photos on Instagram? Comments on Facebook? Is there copyright in the first place? So these are the questions you have to ask yourself. So these are things online, on social media and so on, everything that you post. Do you have copyright? So you're going to see, is there copyright in the first place? So yes, if there's literary work, there's artistic work, there's images. So yeah, there is copyright. So copyright is basically expression of ideas into a medium. Then you look at who owns the copyright. So we visit the rule of thumb. Creator owns the copyright. So are you the creator of what you're posting online? So if you are the creator, then you own the copyright. Well, on the basis of you're not doing it for your employer, if that's your job scope, then your employer owns the copyright. Or you're not doing it for the person commissioning the work. If someone has paid you to create that, then they might own the right. So those two things, looking at whether was it commissioned work or am I an employee? Because those are two ways the right might transfer back to the other party. Then you ask yourself, is there any agreement between you and the social media? Okay, so The first two questions are questions that you should ask for any type of copyright work. Now that we come into social media, you have a third party now. A third party which in fact, all of the time has terms and conditions. How many of us actually read the terms and conditions of the social media that you have signed up to? There's Instagram accounts, there's Pinterest accounts, there's Twitter accounts, there's Facebook accounts. What else we have? We have YouTube accounts, YouTube channels. What are the terms and conditions of all these types of social media? If you haven't read them, well, you can print them out and read them for bedtime reading. And what you will find actually that most of them are very, very similar. So you kind of wonder whether do they all have the same type of lawyers. So do you own copyright in your tweets? 140 characters, is that considered copyright? Well, it depends. 140 characters is sufficient enough to be considered copyright. The reason the question is there is titles of books are not considered copyrights because it's too short. Some sayings are not copyright because it's too short to be considered copyright. So in 140 characters, it is considered copyright. Then let's look at the terms of service in Twitter. In Twitter, the terms say that you own your own tweets, but they go on to say that your rights to any content that you submit are also given to them. You see the second sentence in this slide? By submitting, posting, or displaying content on or through the services, you grant us a worldwide non-exclusive royalty-free license with the right to sub-license. So you're giving Twitter the right to use their work on a worldwide basis, on a non-exclusive basis, and a royalty-free basis, meaning that they don't need to pay anything to you to use their work. And to publish, modify, transmit, display, and distribute the work. Then you also agree that this license includes the right for Twitter to provide, promote, and improve the services, and to make the content submitted to or through the services available to other companies, organizations, or individuals who partner with Twitter. So you're not only giving it to Twitter, you're also allowing them to use it alongside their partners. So what it means is that you own the rights. It's saying that you own your tweets, but you're licensing it with no fee at all to them and their partners. So what's the point of owning it? So that's the funny part about this. It's like, what's the point of owning your tweets if you are pretty much giving up your rights and allowing them to do whatever they want with it? So that's about Twitter. And actually the same thing goes to Instagram and the same thing goes with Facebook, because they all say that you are the owner. It's too wordy, so I do not want to go through it, but they all say that you are the owner of your material, your contents, your images, your text, but you give the social media company a right, non-exclusive, worldwide, and royalty-free right to use the rights. So just very quickly, paragraph 1, for example. Okay, let's just read paragraph 1 to again show that Instagram has got very similar terms to Twitter. So Instagram does not claim any ownership rights in the text, files, images, photos, videos, sounds, musical works, and works of authorship, applications, or any other materials, collectively the content, that you post on or through Instagram services. So it doesn't claim any ownership rights. They're not saying that they are the owner. Next sentence, by displaying or publishing or posting any content on or through the Instagram services, you hereby grant to Instagram a non-exclusive, fully paid, and royalty-free, worldwide, limited license to use, modify, delete from, add to, publicly perform, publicly display, reproduce, and translate such content, including, without limitation, to distributing part or all of the site in any media formats to any media channels, except content not shared publicly. So can you see, they say limited license to use, and right now it doesn't sound limited at all. But what you can see, it ends with except content not shared publicly, meaning private Instagram accounts are not at risk. So if your account's on public display, then it's free for Instagram to use it. Same as Facebook. If your account has a privacy setting and those means that Facebook can't use your material. But where it doesn't have a privacy setting, and the rights, the photos, the videos, your content are then free for them to use. Similar to that, because Facebook says that you grant us a non-exclusive, transferable, sub-licensable, royalty-free, worldwide license to use any IP content that you post or in connection with Facebook, which means any IP licensees. So yes, so basically you want to look at your privacy content, your privacy settings. So that's for social media. And we talked about social media, we talked about websites as well. Now let's look at some cases. We've got some cases to explore in terms of copyright infringement that are very, very interesting, and I hope that you can learn from this and apply it in your business, or just know about it so that you watch your own steps when you're using third-party rights. So this is a very famous case. It's the monkey selfie case. Why is it called a monkey selfie? Well, take a guess. So the monkey took a selfie. This is the selfie of the monkey. See how intelligent monkeys and apes are? Makes sense why Darwin said what he did. So in this case, in 2011, the photographer David Slater set up equipment in Sulawesi, Indonesia. He was actually monitoring the habits of monkeys, and he had a huge set of equipment set up. He went away for a while, and a monkey came in, Naruto was the monkey's name, came in to play with the equipment, and in the process of playing with the equipment, it took a selfie of itself. And the photographer then started using this image. He licensed the image, and it became a huge case in the US, mainly because this photo then became, it was circulated in a lot of blogs, including Wikipedia and a blog called Tech Dirt. So this photographer, David Slater, actually wrote to these parties and told them to stop using his image. It's his image. If you want to use it, please pay a licensing fee. So the blogger in Tech Dirt actually disputed this matter and raised the question on ownership of the photos. And because of that, the photographer took an action against the blogger because they continued to use the photos. And the case was actually publicized to a large extent because it goes to a question of who owns the rights? Who owns the rights to this image? Who created this image? So, okay, who owns copyright? I have been saying the whole time, the rule of thumb is the creator owns the copyright. And the creator here is a monkey. Can a monkey own copyright? So that was, it was a really interesting case. All IP lawyers, all friends of mine were all talking about it. It became a huge thing that everyone was following to see what is the decision going to be. And in 2014, the US Trademark and Patent Office actually issued a decision. So that animals cannot own copyright. And because it was a lot of discussion going on whether it can be, an animal own copyright, and the US IP Office, without waiting for any case, the decision of the court, they themselves issued and assessed the matter and say animals can't own copyright. But in 2015, PETA, the People for the Ethical Treatment of Animals, they filed a suit against Slater, saying that they are suing on behalf of the monkey and claiming that animals are rightful owner, and any proceeds from the images should go into charities that take care of this specific type of monkey, so that the monkeys benefit from it. And the judge in the US court ruled against PETA, and they appealed. So in the appeal, they lost again. Very interesting, because the US district judge said, he decided in favor of the photographer, Slater, said that he owns the copyright. It said that while Congress and the president can extend the protection of law to animals as well as humans, there is no indication in the Copyright Act that that was intended. So they went and, because there is laws for all type of intellectual property right. So they have to go back to the Copyright Act. Again, what does the Copyright Act says? Who's the owner? How the owners reap rewards and so on. So there's nothing in the Copyright Act that indicated that ownership can be for non-humans. So if there needs to be amendment of the Act, it's amended through the Parliament, through the bill. So it's not through the court system. The court system has to rely on the Act. So that was very interesting. But Slater understood where PETA was coming from. So that's really nice that in the end, even though he won the case, as a compromise, he actually agreed to donate 25% of any future revenue from the images that he makes, the images of this monkey selfie, to charities dedicated to protect the crested macaques, that specific type of monkeys in Indonesia. So that's an interesting case of copyright as well. It goes to who owns the rights. Well, here it was a monkey. And then it became a huge debate of, really? Monkeys can own copyright? How are they going to commercialize it? So that's the end of that case. And that brings us to the next case. So the next case is a case of a picture on the left. The picture on the left is actually a black and white photo of a couple holding 8 puppies. Yeah, 8 puppies. A couple are holding 8 puppies. And the photographer used this photograph in note cards and notebooks and greeting cards and so on. His name is Art Rogers. So Art Rogers is a professional artist and photographer. And he created this in 1984 when a card company actually asked him to create something like this so that they can use it. So he got into an agreement with a card company, and they used the image for various versions of the cards, of postcards and greeting cards and so on. The photograph was known as puppies. They called it puppies. So the image on the right side is a 3D version of the photograph. It's a sculpture. This was created by Jeff Koons. So Jeff Koons is a contemporary artist. And what's very interesting is that Jeff Koons obviously came across the postcard and used it to create statues and sculptures. And he was successful. The sculpture that he created, the one on the right, was so successful that he sold it for $367,000 US. So he then made 3 versions of it. He sold 3 editions. So Rogers, interestingly, the way he found out was interesting. So what happened was 1984, the original person, the photographer, Art Rogers, created that image. By 1989, 5 years later, someone called Rogers to say that a colored version of his photograph has appeared in the newspaper. He said, hey, look at the LA Times today. The LA Times is showing your photograph in a colored version. So he's like, wait a minute, this is not mine. So when he did further investigation, he found out that the pictures that appeared in the LA Times were actually sculptures. And the sculptures was exhibited in the LA County Museum of Art. So then, of course, what is he going to do? This guy has made $367,000 and hasn't paid a single cent to the original person, Art Rogers. So Rogers did what a normal human being would do. He sued. He sued Jeff Koons and the gallery that represented Jeff Koons. So Koons' defense was that it was fair use by parody. So parody, remember we talked about parody earlier? We talked about how making fun of something. So the court obviously, when you have a defense of parody, they will then analyze, well, is it parody? Are you making fun of something? So what aspect of making fun of that couple were you doing? What aspect of making fun of those puppies was there? So that defense is then torn apart when they can't actually find something that could show there was a parody. So the decision was the court found, number one, there's resemblance. There is copying because the resemblance is undeniable. Defense was thrown out, so the whole parody, the fact that it was fair use by parody was thrown out. And Rogers won the case at Court of Appeal, and the issue of damages was then sent to the district court. But before damages could be determined, both parties reached a settlement agreement. So that brings us to the next interesting case before us. This case was a case of a Colombian student who was almost jailed for something he posted online. He posted an academic paper online on a digital library, and I'm not sure whether you have heard of it, but there's a document sharing platform called Scribed. Well, he posted it on Scribed, and then he almost faced a jail sentence. So let's explore this case. So Diego Gomez was studying Masters in Conversion and Wildlife Management. As an undergrad student in the university in Colombia, he posted another scientist thesis online. And the reason behind the posting is actually, as when he was doing his research on his master's, he found it very difficult to find information. And when he finally found information, he was so excited about it that he posted it online so that other students like him can learn from the information, from the other scientist thesis. And this thesis was actually found in a library in the city. He had to go to Bogota and found the thesis in a city, and then he posted it online. So the author had an issue and complained to the police. He felt that this is my work. He didn't ask for any permission from me, and he posted it online. And when this case went to court, it became a controversial case because I guess it's the intention of the student. The intention of the student was to share learnings, to share and grow. So was it fair use? So one of the reasons of fair use is that it's educational content. But can you post someone's entire thesis and say it's fair use? So that's a question mark altogether. Because the fair use actually is based on, it's needed for education. But maybe excerpts of it would have been fair, considered fair use. But the whole thesis online, interestingly, in Colombia, it's a criminal offense. It's a criminal offense, and he was facing up to 8 years in jail and 6,000 in fine if found guilty. Colombia has very, very strict copyright laws. And the strict copyright laws also is because they don't want movies to be copyrighted and pirated. So in here, this poor student was caught. But in 2017, thankfully, he was actually cleared. In 2017, Diego Gomez was cleared. And he was funded, his legal fees was funded by a foundation that came together. They did crowdfunding to come together and support him with legal defense costs because they felt that this was unfair. This is not fair and doesn't encourage learning. It's a sharing of knowledge, and it shouldn't be a criminalized practice. So thankfully, he escaped. But it was a lesson to everyone to be very, very careful when they post things online. So on the exact defense that he used, it was very difficult because there was not much information that could be found on the exact defense that his lawyers used to get him scot-free. But it might have been the owner of the copyright itself letting go of the case in this matter, due to the bad publicity that he got, because it was not encouraging of sharing and learning in the country. Okay, the next case, and this is the second last case that we have, is Obama Hope case. So this Obama Hope case, the image on the right is a poster that's extremely famous and is used throughout the Obama campaign. The picture on the left is where the dispute arises. So let's see. The dispute was in 2008. A famous street artist called Shepard Fairey created a poster of Obama, and the design became very popular with Obama's campaign. Fairey generated 400,000 in sales of the images, which was used on websites, posters, stickers, shirts, and buttons. Remember earlier we said that it can be derivative rights, transformative adaptations. So this is where there's copyright in a poster, and then there's various versions of it then created and commercialized, and then it was sold in the marketplace. So in 2009, a freelance photographer who works with Associates Press alleged that the poster was made from his original photo, and therefore Associated Press, or AP, demanded compensation. See, the photographer is an employee of AP. So what we talked about earlier comes into play. As an employee, what he creates in his job scope goes to the employer. So here the AP was demanding compensation. And in this case, Fairey relied on the fair use defense. And at the end of a 2-year lawsuit, the parties settled the matter out of court. So the fair use defense is difficult again here. So what's your fair use when you're using it for commercial reasons? It's not a reporting of any news. There's no parody here. So you go back to reviewing what's the fair use defense, on what cases can you actually use it. So it's a tough one here. But regardless of the fact that AP most likely would have succeeded in this case, both parties got out of the case after the 2-year lawsuit and settled. And interestingly was the settlement terms. So all business disputes have solutions. And I like how both parties came together with an awesome business project or business proposal to work together. So the proposal was that moving forward, both parties are to share the rights to make the posters and merchandises bearing the Hope image. So meaning they both earn the income from posters and merchandises bearing that disputed image. And then also moving forward, Ferry will collaborate with AP on a series of new images he will create based on the original AP images. So that means Ferry will use his creativity to convert images like the Obama image here, the photograph, into a creative version on the right. So the one on the left to the one on the right. So it's concepts like that. So they'll look at other photos that AP has and see what Ferry can do with them. So these are solutions that they both came and agreed with in this dispute, which brings us to the next case. This case is again involves a publication again, a newspaper, Telegraph. Telegraph had a competition, and in the competition, Sarah Skerr took part. She took part and submitted in the contest in 2009, but this was from a visit in 2006 to the San Rafael Glacier. She took this picture, the iceberg in the coast of Chile. She took this photograph and submitted it to Telegraph for one of their contests. And in 2015, 6 years later, a Chilean reporter, Marisol Ortiz, claimed that she was the copyright owner. And she went on Sarah's Facebook and she ranted. She gave a long rant about how Sarah is not the true owner and there's copyright infringement and how can Telegraph have awarded Sarah with the prize money. I think she won. I mean, when Sarah won and Marisol found out and she did that, she went online, Sarah suffered big time because Sarah then had other people attacking her online. And this is common, right? Everyone loves drama. So when someone attacks someone online, you've always got the naysayers who don't do any investigation coming and attacking as well. So she had a huge amount of attack online. Telegraph thankfully investigated the matter and they asked both photographers for original photos. Since they're both claiming that it's their photos, they asked for original photos. And the photographs that Telegraph received indicated that they were both taken on 6th of November 2006. So they were taken on the same day. And there was only a very slight difference in perspective between the two photographs. This is what they found. The two women had captured nearly identical photographs of the same scene at roughly the same moment from roughly the same vantage point. So let's go back to the photograph. So the reason they say it is of the lighting. Can you see the lighting? So the sun is shining on the glacier. And then the image of the light also then is then reflected on the water and the angle of the glacier as well. So they say that all of this means the time of the day was almost similar. So the one, they both taken on the same day, 6th of November 2006, at the same place. And the lighting is almost the same. And it's almost the same angle. So they concluded that both of the women were on the same boat, the same tour boat, taking the photos at around the same time, which means there's no copyright infringement. It's just a highly coincidental matter that both have very similar photos. So in this case, the Marisol Ortiz Elfeld actually, I'm not sure whether she did, but she ought to have apologized to Sarah. So that's what happened in this case. So here, this actually reminds everyone to be very careful, because here Sarah's very lucky that it was actually her photo because of the way they turned out. And you can see that someone can always dispute any images regardless of when you post it. You do have limitation period. So limitation period in intellectual property rights means that you only can take an action 6 years within the date that you find out there is someone copying your work. So if you find out and sit on your rights, then you can't take any action against that person in court. So that brings us to stock images. Can we use them? And a lot of people use a lot of stock images, and we touched on this a bit earlier. So that is actually depending on what is used for. So always read the terms of the license. So a lot of licenses can be free, but they say use it for certain purposes. And the reason we highlight this is because we've had a case where we had a client who engaged a design house. They purchased the stock image lawfully and used it as part of their design for someone's trademark, for another person's trademark. And the person who used it, so the design house purchased an image for a client, the potential client who came to seek advice from us. The client said that no, he has rights in the artistic work in the trademark. And we say, how do you know you have rights? Say, well, the design house purchased it. And we're like, okay, they purchased it. But when you purchase stock images, there's terms of purchase, there's terms of the license. What does the term say? So the terms might say that it cannot be used for other purposes. For example, it cannot be used as a trademark. So then when we were asked to register this trademark, we had to look at all of this. We had to look at who owns the copyright in this trademark. Because if this copyright in a trademark doesn't belong with our client, and we register the trademark might belong to the client, but the copyright might not belong to the client. There's still copyright in the artistic work. So it's very important to actually dissect that trademark to see, is there copyright in this? If there is copyright in this, who owns the copyright in this? So in this case, we had to go and revisit the terms and condition of the stock image. And this was, they bought it from rgbstock.com. So we had to actually look at the stock image and assess whether the terms of this purchase, was it allowing the client to use it as a trademark? And if you can see 3.4, okay, number 2, it says where you can use the image. Number 3, it says where you cannot use the image. So number 2, it says you may use the image 2A in a digital format on websites, blogs, multimedia presentation, broadcast film and video, or on your cell phone or personal computer as screen background or desktop wallpaper. You can use it to decorate your home or your office. In printed materials such as magazines, newspapers, books, flyers, textbooks, wherein the image or images are used for the purpose of illustration and not the primary content for sale or redistribution of the printed materials. So you basically can use it for all your marketing materials. It's an image that can be used. But it says you can't use it for 3.4 as part of a trademark, service mark, or logo without express written permission from the image provider. So immediately it means that when you're purchasing the stock image, you can use it for the reasons in number 2, but you can't use it for the reasons in number 3, including as a trademark. So that brings us to this case. It's very, very important that you're using a brand as a trademark. Be very careful what you're using in the brand itself. Do you own the copyright to that artistic work in the brand? Right. So that brings us to the end. We've explored 6 cases, and I hope that it's been really useful to all of you who've been tuning in. The key learning from this session, in a nutshell, that I hope all of you go back home with, is the overview of copyright in your work. You now know what is copyright, who owns copyright, what is the rule of thumb, and then you know how to safeguard your copyright and how to avoid copyright infringement.
What a wonderful sharing this morning, Miss Gita sharing about our this copyright thing. So make sure when you have a recipe and or idea in your head, make sure you transfer to the medium so that you can claim your copyright, right? So now is Q&A session. We open to the floor. if you have any question, you can type your question in the chat box. So Miss Gita will answer you. So don't be shy. You can ask any question. Just now I got lost some. Yeah, Jean got asking if someone in other country copy the content of our website and put in their website, what can we do?
Very good question. Jean, is it?
Yeah, should be Jean.
So very good question. It's so in all intellectual property rights are jurisdictional, meaning it's country basis. Each country has their own intellectual property law. So the copyright that you put in your website. So the thing is, intellectual property law is country basis, but then internet is kind of global. So we just have to then see that, can you do something about it? You most likely be able to do something about it if they are in a Berne Convention country. So whatever you create and publish in Malaysia enjoys copyright in other countries which are members to the Berne Convention, and many countries are members to the Berne Convention. So we have to actually assess what country are you referring to, and if that's part of the Berne Convention, then yes, you can actually sue someone or take action against someone for misusing your own copyright in their country, in their website. So some countries like the US and Indonesia, you have to lodge the copyright in their IP office, meaning, so with website, for example, we need to put a front end and a back end or images used and lodge it in the IP office so that you can actually sue another party and get better damages. In the US, you can sue even though you haven't lodged it in the IP office, but damages won't be what the best that you can get. Damages will be very low and minimal. So a lot of people actually lodge their copyright in the US because of that. I hope that answers your question, because so it does. It's not so easy to say yes, you can sue. I have to actually justify on what countries you can sue and how do you go about suing it. But yes, so in a quick answer is yes, you can sue.
Thank you, Miss Gita. So we move to another question. It's Raymond. Raymond asking for the recipe that you mentioned earlier. If I were to write in on a piece of paper and then pass it to a person, and then he published a cookbook, do we have a cause of action, or can we only claim that it was a confidential information?
So you write in a piece of paper and you publish a cookbook, that's copyright infringement. So if because you've reduced it to substance, so your ideas have then you've written it out and he's copied it. So we then have to see how much of copying was done. Remember we talked about is it qualitative or quantitative? Has he copied your recipes, your ingredients, and your recipes on how to make the food? And that has been copied word for word in a large chunk of it, then it became a case of copyright infringement.
Thanks, Gita. The next question is how similar is considered copying? Any rules or guidelines when comparing?
So there's no rules or guidelines. Most of it is, if substantial amount of copying, then it's considered copying. So the substantial amount of copying or significant amount, those are the words that you use, substantial or significant. So what is substantial? We don't have an exact percentage, and the courts will not say 70% and above is considered copying. There's no decisions as that in any country because it's too subjective. So we'll have to then assess the work. In one of the cases that we had is there was a top 10 reasons to do something. This company used that, and the competitor used the exact top 10, and they maybe changed one or two words, but a lot of it was copied. So when you compare that, you can see there's a substantial amount of copying. You can say like safely about 80% was copied. And if they went to court to dispute the case, our clients would have won. But this case was settled out of court. So this case didn't even go to court. But the point is that it's a question of, is it a substantial amount of copying? And if there isn't substantial amount, there's just little bit that's copied, was it a significant amount that's copied? So it's too subjective. There isn't any exact numbers or figures I can give. I hope that answers the question.
Thanks, Miss Kita. Well, the next one is Kumar. How long does it take to TM an image trademark an image in Malaysia for business organization? If we add a small modification on the image, would we be liable for copyright issues to both globally and local?
So how long it takes to register a trademark in Malaysia nowadays is about 9 months to 12 months. It's a lot faster than what it used to be. It used to be 2 years, 1.5 to 2 years. So now it's between 9 to 12 months. So that's the first question. The second part of the question is if they've used a certain element in the trademark, very important to identify where you got that element. Who created the element? Is that work original? I guess kind of going back through the questions that we posted out today, who created it or copyright? Is it original? Has it been transferred to you? So those are the questions to actually ask. If it's like, for example, someone created it and transferred the rights, the copyright in that creative work to you, and you're incorporating that as part of the trademark, then there's no issue of trademark copyright infringement. And you then can have the copyright in the brand and the trademark protected.
All right, thank you. I think it's the last question from SB. We often use images, not content, from the internet for slides presented within our organizations, but the slides are not presented in public. Is there any copyright infringement there?
Okay, so this is also a very good question, and we ask quite commonly on this. Let's go back to it, right? Number one, is it your work? No, it's not your work. So it means it's someone else's work. So if it's someone else's work, it's copyright that doesn't belong to you. If you want to use anybody's copyright, you must get permission. Otherwise, yes, it's copyright infringement. But let's look at the fair use, the defense of fair use, the doctrine of fair use. It says that you can actually use copyright for fair use if it's for research purposes, it's for education purposes, if it's for parody, criticism, review. So internal sharing could arguably be for education purposes. So it's again very subjective. If your staff force, let's take this example. It's a Franklin Covey video, a training material. One person has attended a Franklin Covey course and they've learned that and they've got that video. And the video says that you only can use it for personal use. And this person who then works for a large organization and they're a HR trainer for the organization and they've got 2,000 staff. And at their company dinner, they do a sharing and they share the Franklin Covey training for these 2,000 people. So is it educational? When actually they should have paid for that and permission should have got to display that to 2,000 people. So it really depends. It's very difficult to answer this question because I'm just sharing with 2 people in my team, saying that, hey, this is how we should learn, this is how we should lead the team, watch this video. That can be just for education, for training purposes. But if it's for 2,000 people and something that was only meant to be personal, that would be infringement of copyright. They look at, is it doctrine of fair use? So it's very subjective and it goes on a case-by-case basis. But rule of thumb is, if it's not yours, get permission. That's actually rule of thumb.
Well, I think it's the last question already, right?
I think that's what you said.
Yes. Thank you so much. Thank you, Miss Gita, for your lovely morning to share about our this copywriting. Then, well, thank you so much, and we'll see you again. Thank you.
Thank you, everyone. Thanks, everyone. Bye.
Thanks, everyone. Bye-bye.